Hello, my name is Judge Todd Taylor. I'm a district court judge in the 19th Judicial District in Weld County. I'm going to talk today about restitution. Restitution is a critical part of a criminal sentence and must be considered when imposing every sentence. For this reason, a sentence is illegal if the court fails to consider and fix the amount of restitution. In enacting the restitution statutes, our General Assembly has made clear that restitution is intended to make the victim whole to the extent possible, to rehabilitate the offender, and to deter future criminal conduct. Thus, unless the court makes a finding that no victim of the offense suffered a pecuniary loss, the sentencing court is required to order the defendant to make restitution in all cases involving a conviction of a felony, misdemeanor, petty offenses, or traffic misdemeanor offenses, including juvenile adjudications. For restitution purposes, a conviction means a guilty verdict, a guilty plea, or a no contest plea, or being placed on a deferred judgment and sentence. Restitution is made a condition of any sentence to probation, and in prison sentences is made a condition of parole. The restitution statute makes clear that persons found guilty of a crime should be, quote, under a moral and legal obligation to make full restitution to those harmed by their conduct. Thus, a court may only deny restitution after finding that the victim has not suffered a pecuniary loss, and not because of the offender's inability to pay. Defendants who cause the same pecuniary loss are jointly and severally liable for restitution. The definition of victim under the statute is broad. Victim includes any person aggrieved by a defendant, which means that not only the person immediately and directly aggrieved by an offender is considered to be the victim, but also that person's immediate family members, such as a spouse or child. A victim compensation board that has paid a victim compensation claim is also considered to be a victim for restitution purposes. Also included in the definition is any person or entity that suffered a loss because of a contractual obligation with the victim, such as an insurer. There is no requirement that the person or entity be named as a victim in the charging document to be eligible to recover restitution, so long as the person is immediately or directly aggrieved by the defendant's criminal act. If a victim is deceased or incapacitated, a family member, such as the person's spouse, parent, legal guardian, or child, or a lawful representative, may request and recover restitution on the victim's behalf. The court must order restitution in an amount equal to the full amount of the victim's pecuniary loss. Pecuniary loss is any loss suffered by a victim that can be reasonably calculated and compensated in money, and includes, but is not limited to, 1. All out-of-pocket expenses, interest, loss of use of money or anticipated future expenses. 2. Rewards paid by victims. 3. Money advanced by law enforcement agencies. 4. Adjustment expenses. And 5. Other losses or injuries proximately caused by an offender's conduct. Restitution includes extraordinary direct public and all private investigative costs. But restitution does not include damages for physical or mental pain and suffering, loss of consortium, loss of enjoyment of life, loss of future earnings, or punitive damages. For non-felony traffic offenses, the court is required to order restitution for only that portion of the victim's pecuniary loss that is not compensable from the defendant's insurance policy or other applicable insurance coverage. Pecuniary loss may also include incidental costs, such as interest paid out by the victim, the cost of counseling for the victim, and the victim's family, expenses incurred by the victim in an attempt to recover stolen property, including attorney's fees, or the value of time spent by a corporate victim's employees cooperating with law enforcement and the prosecutor. A court may order a defendant to pay restitution for pecuniary losses resulting from uncharged criminal conduct or resulting from dismissed counts, but the statute of limitations applies to restitution orders, and a defendant cannot be ordered to pay restitution related to criminal acts for which prosecution is time-barred. In determining the proper amount of restitution, the court is not bound by strict rules of civil damages so long as the record supports the court's finding that the valuation method used is reasonable to make the victim whole to the extent practicable. Restitution is a criminal penalty, however, and the court has authority to order restitution only for pecuniary losses resulting from the defendant's criminal conduct. Restitution is not a substitute for a civil action for damages. This means that release from civil liability does not necessarily limit the criminal court's authority to order restitution equal to a victim's actual pecuniary losses, but an order for restitution may be decreased if the defendant has otherwise compensated the victim or if both the prosecutor and the victim consent. The amount of restitution must be determined when the order of conviction is entered or within 90 days immediately following the date of conviction. Be sure to consider restitution any time that you impose a sentence.